So I'd like to introduce our speaker today, attorney Jason Brown from the law firm of Barna, Guzzi and Steffen. I will go ahead and turn it over to you, Jason.
All right, thanks, and good afternoon, everybody. I persistently and inappropriately continue to tell folks it's great to see you when I'm on Zoom, when the reality is I'm looking into a camera. We've all become amateur broadcasters over the last 2 years, judges in particular, given how much time in your day we know is spent on Zoom. But it is good to be with you. Maybe that's a better thing to say. A little bit about myself. I'm a family law attorney. I've been practicing for almost 22 years now. And family law is kind of the predominant area that I do practice in. And some of you may have had the experience of kind of sitting through a CLE or two with me over the last several years. I've presented a number of sessions to the judiciary or to the judicial branch, typically again on family court issues. I was asked to talk today about an area that on its face seems relatively straightforward, but can actually involve a lot of complicating factors. And so we'll just kind of dive right in and talk about a real simple hypothetical. And the hypothetical is this. Let's suppose that as a lawyer, you're sitting in your office and the telephone rings. Person on the other end says that they are being accused of striking or punching their child in the gut. And they ask you for your help. And as a lawyer, you're sitting there and you're pondering and you're suggesting, to yourself internally, well, yeah, I think I can help this person. Maybe they're going to be charged with a crime. Maybe there's going to be implications with regard to a custody action. Maybe the parties will divorce as a result of this conduct. Maybe protective services will get involved. Maybe there'll be a petition for an order for protection. And so as you sit and think about it, I think that it becomes clear that the road ahead in a very simple fact scenario can become really complicated really, really quickly. And I think that one way to represent that is by virtue of kind of having a roundabout. We're all becoming more and more familiar with these as Minnesota embraces the roundabout trend. And when I look at this, roundabout, I think that it's got 4 basic roads that, a scenario like this could go down. It could go down the criminal path. It could go down a path involving a civil action, like an order for protection. It could involve juvenile court, or it could involve family court. And to more concretely or specifically kind of put that into play, the immediate concerns would be an assault charge, custody action, a child protective services case, or an order for protection. And so what do you do as a lawyer, whether you're a seasoned criminal defense attorney or you're fresh out of school or a clerkship and you're sitting at your desk saying, can I help this person? It can be a little disheartening, right? The idea that you've got these 4 areas of law that are quickly going to intersect in a way that maybe wasn't taught to us in law school, isn't the linear path that we're used to traveling down as specialists in the practice of law. And my hope today is that we can turn that frown upside down and get everybody on the same page and understand that, okay, there are 4 distinct areas we have to wrestle with, just to try to give you some sense of what those areas look like, so that when that phone call comes in, you have some roadmap to offer to that potential client. Because a mistake in one area could yield a terrible result in another. They are overlapping. There are different burdens of proof. There are different rules of procedure. There are all sorts of differences in the way that each of these 4 different types of cases will need to be handled. And so we'll kind of talk through those today. And this is really meant to be kind of a broad issue checklist kind of orientation to, where things might be headed for this particular individual in any of these four contexts. Now, the reason that I kind of put this presentation together is by virtue of lessons I've learned over the years. Sitting in my office, getting a call like this and wanting to do the best I can for a client, but not necessarily understanding right out of the chute that there are, issues that cross over one another. There are differences in how things are going to proceed, and there are some very serious implications that can fall on people, whether that's a personal implication or a legal implication. And so I thought that it might be something that would be useful to those who practice in any of the areas that we'll kind of talk about today. So let's dive in first by talking about the civil branch, or the civil road, the civil path this case could go down. And that is predominantly in the form of someone seeking an order for protection. Most of us that work within either criminal or family law or within the courthouse certainly have had experience in dealing with orders for protection. There is a wide swath of folks who are listening in today, and so I'm not going to assume that everybody understands all of these areas. In fact, I'm going to assume the contrary, that most may not have a command of all four of these different roads that are going to be traveled, and so we'll try to kind of break those down and make sense of all of this. So with an order for protection, it's a civil matter. It's a civil lawsuit brought between or by one person against another. And the statutes have an act. It's a single statute, Minnesota 518B.01, which is known as the Domestic Abuse Act. And what that act does at its core is make it an enhanceable crime for someone to engage in certain otherwise legal behaviors, things like talking to someone, or being in the presence of someone, or being at a particular location. An order for protection precludes communication. It precludes being near or at someone's residence. And if someone violates that order, they can and most likely will be charged with a crime. And that crime is an enhanceable crime, meaning that in the first instance, it's a misdemeanor. The next time it gets charged out, it's a gross misdemeanor. And then, third time it becomes a felony. Clients need to understand the severity with which a violation of an order for protection can have fallout on their lives. And what I do find as a practitioner in getting the call, even if a client knows there's an order for protection in effect against them, more often than not, it seems that client doesn't necessarily take all that seriously, the implication of the order. So make sure if you speak with clients at some point about, whether or not this is a big deal, the answer is absolutely yes. And things can happen very quickly. I had a client, probably 15 years ago now, who decided he was going to ignore an order for protection on day one, and then he ignored it on day two, and then he ignored it on day three. And by the end of the week, he had a felony criminal charge against him as a result of these other charges that were also pending because it was an enhanceable offense. And each violation is a separate crime. So what are the bases for an order for protection? Understand there have to be two thresholds met. First, the relationship of the parties. There has to be a relationship of either a familial nature, or they have to be living in the same household as one another. Family is defined as husband and wife. It's defined as two individuals who have a child together. It's defined as a parent and child. And there has to be the existence of an act of domestic abuse as defined in the law. The act of domestic abuse can take number of different forms, and we'll talk about those in just a minute. The burden of proof, this is important, the burden of proof in a civil action, as most of us are aware, is a mere preponderance of the evidence standard. In a criminal case, it's a beyond a reasonable doubt standard. In a child protective services case, it's the standard is somewhere between clear and convincing evidence. So just understand that the likelihood of success is greater if someone pursues a civil remedy than it is if they pursue a criminal charge against individuals. So preponderance of the evidence standard in family court regarding an order for protection. What qualifies as an act of domestic abuse? Naturally, physical harm upon someone. Keep in mind the harm does not have to result in either great bodily injury or serious bodily injury. There just needs to be some physical act that results in harm. What I find is that that term is typically construed somewhat liberally by the court. There's an interest in protecting individuals and ensuring that future acts don't occur. There's also the infliction of fear of imminent physical harm, meaning that someone doesn't necessarily strike someone, but perhaps they threaten to strike someone. And the question there becomes, all right, is that fear reasonable and is it imminent? In other words, has it happened in the recent past? It can include sexual misconduct, naturally, a form of assault, sexual assault, or interference with a 911 call. So with regard to an order for protection, the simplest type of relief to seek is either going to be, the actual tangible act of assault, the striking of the child in the gut. But when we deal with fear of imminent physical harm, in other words, whether there's a threat that's made, the question becomes one of timeliness and reasonableness. In the case of a situation where someone is threatened, how much time passes before the fear that they are expressing continues to be reasonable? Could it be a week? Could it be a month? Could it be a year? Those are questions that tend to come up in cases where someone is threatened. And what I find is, generally speaking, when there is a request based on a threat, the closer in time to the filing of the petition to the threat, the far more likelihood of success that the litigant will have in pursuing that. But the other question is that fear reasonable? That's more of an objective standard. Is it reasonable in light of what was uttered? Is it reasonable in light of the history of the parties or the nonverbal cues that were offered by the individual that perpetrated the act? We'll contrast that with an act of assault, which under the law does not need to be timely. This was a recent development in the law. In 2018, it really wasn't a development. I suppose technically it was sort of a refinement by the Minnesota Supreme Court in the Thompson case. In that case, the litigant came in and she was filing an order for protection on behalf of a child. And when the petition was filed in 2015, the core of the allegation in the petition was that that individual had committed acts of assault upon a child between 2010 and 2012. And so the court in that case, as a result of incidents that had occurred 3 years prior, still entered an order for protection, went up on appeal to the Court of Appeals. The individual who had the order for protection issued against them appealed, arguing that no, there needs to be some imminent act of assault in order for there to be a sufficient cause of action for an order for protection. But the Supreme Court suggested and refined and noted that within the statute, where it speaks of physical harm, and speaks of infliction of fear of imminent physical harm. Nowhere under physical harm is the word imminent appear. And so the court is not necessarily going to dismiss an order for protection if someone petitions based on an act of assault that took place sometime prior to the timing of or filing of the petition. But that said, it doesn't give carte blanche permission for people to just assume they're going to get an order based upon the fact that at some point in time an act of assault occurred. In other words, the court can look at the totality of the circumstances and will do so. And if under the totality of the circumstances, it seems that it is appropriate to enter a protective order to make it a crime for someone to engage in an act that is otherwise typically considered legal, they'll look at all of the circumstances surrounding that. So just be clear about that. An order for protection case is commenced by filing a petition with the court. In the case of a child, it needs to be filed by a reputable adult over the age of 25, or the statute says a mature child who is 16 years of age or older. The maturity of the child will be taken into consideration by the court in determining whether it's inherently a reliable petition. Venue for an order for protection is going to rest in the county in which either party is a resident, or the county in which there is a pending or a completed family court action, or where the actual act of domestic abuse had occurred. So lots of different alternatives for venue. The statute points out that orders for protection get docket priority. There's a waiver of filing and service fees. There's a simplified set of forms and clerical assistance available to litigants who are seeking an order for protection. I think from a public policy standpoint, the idea is to make this a very accessible and prioritized cause of action, so that people who have been either threatened or have actually been assaulted or harmed have a quick way to the courthouse. The petition in an order for protection is filed ex parte, meaning that you don't have to give notice to the other side. You simply file your petition, and the court will do one of two things. The court will either grant a temporary order for protection and then set the matter on for a hearing, or the court will deny the temporary order for protection and typically set it on for a hearing if the petitioning party has asked for a hearing, if the initial request for the temporary order is denied. So lots of different ways that this can work its way through the court system. But the idea is that a litigant can do so privately without notice to the other side. And sometimes there's some strategy about when those petitions are filed in terms of timing, in terms of when to get them served, et cetera. But just know that it has been my experience anyway, that if there's even a question as to whether something is construed, if accepted as true, as an act of domestic violence or domestic abuse, the court tends to err on the side of caution. Now, and grant the temporary order. Now, keep in mind the statute also has a series of very quick timelines for hearings to take place. And so, from a due process or fundamental rights perspective, one who has a temporary order issued against them has the right to get into court relatively quickly and have the merits of that addressed. Now, in order for protection, a lot of litigants kind of get, and lawyers too, actually, kind of get this confused. Many litigants want to try to do a lot of things with an order for protection, but the way I describe, petitioning for an order for protection is that it is a very narrow, focused lawsuit. The only question before the court, the only question is whether an act of domestic abuse, as defined by law, has occurred between the parties, and that's it. Court generally does not want to hear about the family history. The court doesn't want to hear about what cars people own. The court doesn't want to get involved in divvying up personal property. The court doesn't want testimony about things that are unrelated to acts of domestic abuse. And so understand that within the statute, there are some very specific and limited switches, if you will, the court has available to grant to a petitioning party. Of course, they can restrain further acts. The court can exclude from a home or an area surrounding a home the person against whom the petition is filed. The court can grant an award of temporary custody and temporary support. It has been my experience, however, that the judiciary seems to have a little resistance to doing too much in the way of parenting time or child support or spousal maintenance on a temporary basis in the context of an order for protection. And I think the reason is that the statute is set up to really address the fundamental question, number one, of whether an act of abuse has occurred. But I think second, and as important, I mentioned this in just a bit in the slides, some people, as you might expect, will use the system as a sword rather than a shield. They will use it to try to circumvent or shortcut the family court process, where you have to go in, file pleadings, put together affidavits, those kinds of things. They're trying to use it as a shortcut. Not always, of course, but in cases where that is happening, it tends to frustrate the fundamental purpose of the order, which is to create a shield for people, not enable people to use it as a weapon or use it as a way to get what they want quickly. Court can also issue a no contact order. They can, I haven't seen it happen all that often, order restitution, order the offending party to go to counseling, order them to maintain all insurance, which is already a fundamental requirement as part of a dissolution action if one is going to be pending. And then the court does have the authority to issue an order surrounding pets and preclude people from harming pets. So Rover gets his protection under the statute as well. Duration, an order for protection cannot exceed 2 years unless the court deems otherwise, so it's discretionary, but typically it's entered for up to 2 years. And I find that that is the most typical result. It's kind of a rare circumstance, frankly, if an order were to issue for a period of just 6 months or a year, but it does happen from time to time. Extensions are available for an order if there's a violation of the order while it's in effect, if there's a reasonable fear for safety even after the order is issued, the party requesting the extension, if they can show they've been harassed, or, and this is important, if the offending party is soon to be released from prison or has pending incarceration, where there's going to be an opportunity for that person who really hasn't had 2 years on the street, so to speak, to commit a violation from getting out and doing something that would be inappropriate. One very important fallout from the issuance of an order for protection is this: firearms possession is going to be precluded by the offending party under the Violence Against Women's Act. That's the VAWA acronym I've included here. If an order for protection issues, generally speaking, they've got to turn firearms over to another individual and then file proof of that transfer with the court in the form of an affidavit. Now, one nuance with regard to this is that the federal laws say that it needs to be what they call a qualifying protective order. Lawyers can sometimes be creative. If there's a hearing, for example, someone goes in and they have the option of saying, I admit to the allegations, let the order enter. I deny the allegations, I want a hearing. Or they can come in and say, I deny the allegations, but I don't care if an order issues, issue one without findings. If there's a hearing, that hearing is, if there is an order issued, going to find that there is a need for protection for the individual that petitioned, and a finding that that person did commit an act of abuse. And so that would certainly be a qualifying order. Where you can get creative is, and I had this come up one time where I represented a police officer who was accused of engaging in an act of domestic violence in the home. And we spent hours trying to craft and narrowly tailor an order that had no findings that he committed, an inappropriate act, but also got around the federal rules about what type of an order is a qualifying protective order. Without getting too deep into this, if you represent someone who feels that, their job depends on their ability to carry a firearm, or more often than not, it's someone who really wants to recreationally hunt or something like that. There are ways around this, but only in the context of having an order enter without findings, and only if there's very specific language that would qualify it as an exemption under the federal law. Important to note that a respondent's testimony in an order for protection proceeding, a civil action, is inadmissible if there is a trailing criminal proceeding. So if you have a client who at some point is accused of this and they testify, that testimony cannot be used against them in the criminal proceeding. Compare that, though, with the statute that says that it can and really shall be used in family and juvenile court, and they must take it into account. So the bottom line is there's always a risk if you have a client who's going in to testify in an order for protection. Criminal liability and use of that testimony can be somewhat shielded, but anything they say under oath can come in the form of impeachable material when it comes to both the family court or the juvenile court actions that we'll talk about here in just a moment. I mentioned this earlier, so I won't spend a great deal more time on it, but seeking an order for protection is not a substitute for a family court action. Some will file, again, a meritless OFP in an effort to circumvent, typical processes. Judges do not like it when people try to do that. And in fact, more often than not, what I've seen, even if there's a merited OFP, is to say, take up the issues surrounding custody and parenting time, in family court, where it can be dealt with in a much more robust manner. So we've talked through the civil action. Let's talk now about family court implications. And what I'm going to frame this as is a custody proceeding, a proceeding that can involve either a paternity action, where we've got a couple with a child who is born outside of wedlock, or a divorce action, where the children have a marriage termination coming up, but they also have children. And we need to figure out what's going to happen with regard to the children, with regard to custody and parenting time. Of course, as in civil court, family court is kind of a branch of civil, if you will. And again, it's a preponderance of the evidence standard. Is it more likely than not that something happened? And so if you have a client coming in saying, well, I don't think the state can prove beyond a reasonable doubt that I did this, you've got to remind them that the exposure they have, just purely by virtue of the fact that there's a different burden of proof, is far greater in family court and in civil court. So a family court proceeding, either as a dissolution or as a paternity action, can include either an initial determination or a modification of custody or parenting time. So we have this initial action that can be brought in the first instance, and then there are motions to modify custody and parenting time. The initial custody determination invokes, basically in an isolated way, the 12 best interest of the child factors that we find in Minnesota Statute 518.17. And one of those 12 best interest factors, not one of which is supposed to predominate, but one of those factors involves whether acts of domestic abuse have occurred between the parties. Factor number 4 says that whether acts of domestic abuse as defined in 518B.01, in other words, this is kind of a first example of some interlocking between a family court proceeding and the order for protection civil proceeding, because in family court they use the same definition of domestic abuse as they use in the Minnesota Domestic Abuse Act. Of course, there's consistency, but there's a cross-reference there. So whether it's occurred But the court and family court is also going to take a look at the nature and the context of the acts of domestic abuse. The court will look at things like, well, how often has this happened? What was the severity, if any, of the injury that resulted? Was a child exposed to the abuse? What impact has that witnessing had on the child? Was the child themselves a victim of domestic abuse? Is this something that both parties were involved in, to the extent that one is trying to blame the other? So the court has this discretion and, in fact, a mandate to take a look at what is the nature and context of an act of domestic abuse. The idea, I think, is to say, all right, look, if striking a child is technically an act of domestic abuse, there is a question about whether that particular act has a significant enough implication in a custody proceeding to tip the scale, one direction or the other. It's the question we'll talk about in a little bit. Is there a difference between disciplining a child and assaulting a child? Obviously, there is a difference, but what is the difference? You have to look at the context and the nature of the abuse. The court will also look at implications like the child's safety, their well-being, and developmental needs. So, relief, if you are making an initial custody determination, if you're seeking an initial custody decision by the court, you're filing for divorce or you're filing a petition for a paternity in custody, you can do it in one of three ways. If the client calls you up and they're on the other side of the coin and they say, my child was struck by my spouse, what can I do? You have the option of filing an emergency motion. You can right away try to get in front of the court before anything else happens in the case, if it is a bona fide emergency. And that's crucial. What's an emergency to a district court judge quite often is very different than what the masses define an emergency as. And you've got to use your own professional discretion. You've got to use your best, your best thought process about whether something truly is an emergency. An emergency truly means it is crucial. It is mission critical. We've got to get this child out of a circumstance that could endanger her. So just bear in mind that quite often you can file for an emergency motion. The court doesn't find it to be an emergency. Doesn't mean you're out of luck, just means it's not an emergency. There's also a standard motion for temporary relief. If you have filed for divorce and you wish to seek temporary relief to have a child removed from the care of that other parent as a result of something inappropriate that they've done, you can file that standard motion, or you can always wait for a final trial on the merits. So those are the three ways that relief can actually be sought through the process of divorce or a custody action. Trial witnesses in a custody proceeding typically include any eyewitnesses to the incident, any responding officers who might be able to offer insight into what transpired, or what they, probably more pertinently, what they came to learn upon their arrival at the scene. You can have treating doctors testify about the nature of injuries a child may have sustained. A custody evaluator will get involved and weigh all of these best interest factors, or have a guardian ad litem appointed to investigate. So one thing to keep in mind too is, let's suppose that a parent is found, using that preponderance of the evidence standard, to have endangered a child. And let's suppose that the court wants to do something about it. There is no higher standing or regard that the legal system has relationally than that of a parent and child. And so just because a parent has done something that is, by all accounts, wholly inappropriate, does not necessarily mean that they will never be able to see their child or be denied access to that child. Now, is the court going to do some things that are very strict and designed to keep that child safe? Absolutely, and rightly so. Those can include things like phone or video visits only. With this emergent technology, Zoom and everything else that we've now come to enjoy, if you will. I've worked with a number of folks who have dealt with phone or video calls a couple times a week, so that there's at least a face-to-face type contact that the parents can have. But typically that is still kind of a supervised contact. People are not just given discretion to pick up the video phone and talk to their child in a way that might inappropriately influence them or mistreat them. Child parenting time can take place at a safety center where, there are cameras everywhere. There are trained professionals who are there to keep an eye on the child. When clients of mine object to the idea that the other offending spouse shouldn't even have the ability to spend time with a child at a safety center, I remind them that the Department of Corrections allows for inmates to spend time with children under very limited conditions, and so it is in family court. Sometimes parenting time will be supervised by a third party, either a trusted family member or mutual friend. And I've also seen in some circumstances parenting time occur in a public location. Maybe the court orders that parenting time occur at a local park where they spend a couple hours together, the offending parent and the child. But usually that follows kind of incrementally some of these other actions first. Someone may start at a safety center, and then when a guardian ad litem deems it appropriate, maybe they move to supervised by a third party, and then again, maybe move to time in a public location. The court still, though, does have the ability to suspend parenting time outright. I don't see it happen all that often, but often enough if the allegations are serious enough. I mean, there can be a suspension for sure. So that's an initial custody determination. We'll compare that to a custody modification proceeding, which invokes a 4-factor test. This involves a situation where they've already got a court order, the child is struck, and then a parent wants to do something about it. Maybe they want to change custody or parenting time. So a 4-factor test and a 2-step process. Let's kind of walk through those. But before we do that, I should point out this age-old question that I get, and I don't know that there's an absolute answer. If anyone has any insight, let me know. The question I get pretty often is this. The client says, well, do I have to abide by the existing order if I think that my child is endangered in the home of the other parent? And as officers of the court, we cannot and should not encourage clients to violate a court order, right? But at the same time, we can hardly feel good about saying to them, well, the court order is there. You've got to send your child into circumstances that you feel are harmful. Now go do it. What I have found is that the answer generally rests in, if a parent truly feels their child is endangered, they ought to seek relief promptly and not put that child in danger. I think that on balance, the court would be less offended if there was a circumstance that came up where an individual decided on their own to violate a court order for purposes of looking out for that child's best interest, as opposed to a party who says, well, there was this incident, and again, looking at the nature and context, it wasn't overly severe, just decides unilaterally, I'm just going to withhold parenting time and make a mountain out of a molehill on this. You can get a different outcome depending upon what the facts and circumstances are. But the last thing we should be doing is telling people, yeah, go ahead and violate the court order. The way that I tend to frame it is, if you feel your child is in danger, I think that it is fair for you to at least take a time out from the existing parenting time schedule, let things cool down. But then as a lawyer, try to work with the other side to come up with something. Maybe you can agree on a temporary supervised schedule, something like that, just to have a safety net in place to prevent things from happening. But here's that 4-factor test when it comes to modification. There has to be a change in circumstance since the issuance of the court's original custody order or most recent custody order. It's got to be in the child's best interests. And that's, the same standard that applies to an initial determination. You have to have endangerment. This is where the act of domestic abuse comes in most often. If there's an act of domestic abuse, is the child's physical or emotional well-being in danger in the care of the other parent. And then the court must weigh the benefit versus the burden of making a modification. So that's the 4-part test. It's the Nice-Peterson standard, named after a case from, probably 40 years ago now, Nice-Peterson versus Nice-Peterson. Procedurally, what you need to do is file a motion first with affidavits, and the court is to accept the allegations that are raised in those affidavits as true. And if they are accepted as true, is there a prima facie basis to modify custody? It's kind of like a probable cause determination in criminal court. If the court accepts the allegations in the criminal complaint as true, does it rise to the level of a chargeable offense? And if the answer is yes, then the court, I think there's a mandate, a mandatory appointment of a guardian, set the matter for an evidentiary hearing. If not, if it doesn't rise to the level of endangerment, then that initial motion is simply denied and the case is over. So the first step is file the motion, let the court make the initial determination, and then second step, evidentiary hearing in the event that there is a prima facie basis to proceed. Now, the role of responsive pleadings in a case like this can be a little challenging. Responsive pleadings can only be used to put the moving party's claims into context. However, I do find that there's more than just that context given to the responding party's pleadings. At least it's been my experience. It's a tightrope walk for the court. Is a claim made by a responding party putting something into context or addressing the merits of the claim? Any of you could tell me, but anyway, it's supposed to be looked at only for context and explaining away certain things. If there's an evidentiary hearing, it's going to be a trial, generally involve the same types of witnesses as that initial custody determination. Now, understand that when it comes to modification and initial determinations too, anybody who makes a false claim of abuse of a child in family court can face some very serious consequences. And that in and of itself can serve as a basis to modify custody later. So if you have a client that you think might be overdoing it, who might be construed as someone who is raising a false claim, you've got to walk a very careful road with them and explain to them that there can be some serious consequences if they are found to have made a false claim, and the tables can really turn on them quickly if that's the case. Okay, so last two areas. Criminal cases, we're typically thinking about assault charges. Again, the client calls you and says, I've been accused of striking my child in the gut. Can you help me? Question is, okay, are they going to face criminal charges? And the burden of proof, as we all know, in a criminal case is beyond a reasonable doubt. Assault, just to know, it's also an enhanceable offense, meaning that one assault becomes another, it becomes a misdemeanor, gross misdemeanor, and then ultimately a felony. So we're talking about offenses that kind of build on each other. Fifth degree assault is kind of the generic form of assault. Basically, if someone has caused either fear of bodily injury or intentionally inflicts or attempts to inflict bodily harm. This is almost a mirrored, recitation of the first statute we looked at, the Minnesota Domestic Abuse Act's definition of domestic abuse. It's either an act of assault or the infliction of fear of assault or bodily harm. The stakes get a lot higher if there is substantial bodily harm. Substantial bodily harm, a third degree assault, involves temporary but significant disfigurement, including, say, a fracture or a temporary loss of a bodily function. Second degree, it involves that same substantial bodily injury or harm, but also includes a dangerous weapon, And then first-degree assault involves infliction of great bodily harm, which means that there's a very high probability of death or the causing of serious disfigurement or loss or impairment or function of an organ on a permanent basis. So if the client calls you up and they say, hey, I struck my child, can you help me? And you're thinking about it from a criminal perspective. What's really important is to, number one, figure out what's the nature of the alleged injury, because that'll frame how serious the case is. The second thing you'll want to do, though, is figure out, is there a history of prior acts, because that could result in an enhanced charge. And then, the third part of this is, will there be a charge beyond mere assault? And there's a malicious punishment statute that makes a crime out of balancing a parent's right to discipline against the standard of reasonableness and take into account severity of the act and the age of the child. So punishment cases, if this was, let's suppose, a punch to the gut obviously is not discipline, right? I don't think that any jurisdiction in this state or elsewhere would say that that's an appropriate form of discipline of a child. But in Minnesota, parents do have the right to physically discipline their children. What is reasonable? Is a spanking reasonable? Is spanking with a wooden spoon reasonable? How about a spanking with the belt? How about if the child is clothed? What if they're not clothed? What if there's bruising? What if there's bleeding? How many strikes? How much force with the strikes? I've been involved in a number of cases where some of these lines can be very unpredictable. And you don't know, is the court, or if it's a jury, is the trier of fact, or the finder of fact rather, are they going to find that the conduct of the perpetrator is or was reasonable? And, obviously, as society changes, as norms change, the standard of reasonableness changes. I will admit to you, when I was a kid, I got a little, whack on the rear end with a belt. I was 10 years old, and I was probably doing something I wasn't supposed to. But when I was 10 years old, it was the late 70s, and everybody was just, all about love. Well, not that, but the idea, maybe it was tough love. But the bottom line is that, over time, we have become what we think is more sophisticated, right? And the idea that disciplining a child physically is no longer as universally accepted, perhaps, as it once was, if it ever was. And so you have to just be cautious. There are some cases that address, and they're frustrating cases to read, where the Court of Appeals has found that, a parent who has taken a wooden spoon to the back end of a bare-bottomed child, that is acceptable, that's reasonable, under the law, when your own personal view, may be different. So just something to be aware of, that, the reasonableness of the act, malicious punishment cases, they can be dicey. So those are the criminal cases. We'll kind of wrap up with talking about juvenile court and CHIPS proceedings. A CHIPS proceeding is an acronym. It stands for Child in Need of Protective Services. And CHIPS cases, they don't involve the preponderance of the evidence standard. They don't involve the beyond a reasonable doubt standard. They involve a clear and convincing standard. So somewhere in between, more likely than not, and beyond a reasonable doubt. So protective services, the mission is simple. The state wants to and is charged with addressing circumstances that involve a downfall to a child's health, safety, or welfare, try to correct them. It's a correctional mission. The idea that not every parent went to parenting school and got their certificate and is a verified rock solid individual. And so we have to figure out a way to address the immediate shortcomings in households in order to hopefully make things better for the future for these kids and society in general. Understand that anybody can report a concern to protective services. Mandated reporters are required to do so. Who are mandated reporters? Typically, they are counselors or therapists. Teachers are mandated reporters. Law enforcement probably is a mandated reporter. So there are folks who professionally hold credentials that are contingent upon them taking an oath to report when there is something to report. They are required to do so. And the identity of the one who reports an inappropriate act or circumstance is to remain confidential. It doesn't always remain confidential. If you get redacted CHIPS reports, you can, through deductive reasoning, figure out who's the person that reported, but it's supposed to remain confidential, and for good reason. What happens then is there's an immediate investigation through protective services with the hope that a parent will voluntarily enter into a safety plan. So a first meeting between protective services and a parent is just that. It's just an opportunity for them to talk and see if they will be willing to do some things that can correct a situation that is posing a threat to a child. Sometimes parents will do so, and then matters can come to a close, relatively quickly. In this instance, it might be, if someone was struck, a child was struck, it might be that the parent is going to go through the Tubman program, or they are going to participate in some sort of counseling and follow up and prove to protective services that they've done that in an effort to address the circumstances. If there was no tangible, visible injury, to the child. Of course, it can vary widely if a child is physically harmed in a much more severe way. But just using that as an example of, hey, they'll come out, they'll try to work with you and see if we can get the situation under control. The problem is not everybody is going to voluntarily do that. And if they don't want to address the situation involuntarily, or voluntarily rather, then they'll have to deal with it involuntarily, and protective services can file their petition with the juvenile court. And that petition then will come up with some sort of a case plan as recommended by the protective services agent, a plan that will try to remedy whatever the issue is. If the parents remain unwilling or unable to remedy the situation, that could lead to an ultimate termination of a parent's parental rights. The obligation of the state is to maintain active efforts for at least a year to rehabilitate, to get that situation under control before the state has the ability, court system has the ability to, formally terminate parental rights. I've been involved. I clerked for a judge when I got out of law school, and we had a couple of cases involving terminations of parental rights. And growing up in the suburbs and not being exposed to much more than farm fields when I was a kid, it shocked the heck out of me to see that there were bases for people to have their parental rights terminated. Compare that though with the appellate decisions that I read, and often enough, I write a column for the Minnesota Lawyer. Often enough, there are cases that are reversed, termination cases. And it seems that the crucial reason for reversal of the termination is criticism by the Court of Appeals that not enough was done by the state to try to remedy the situation. There may have been a more passive approach to trying to remedy the situation. There may not have been active efforts. And so that can result in, that finding being reversed. So you think you got it, right? You're in your office, wink, wink. I now know that there's the SALT case. I know there could be a custody implication here. There could be a CHIPS action. There could be an order for protection. So, I got this, right? I mean, hey, I'm a lawyer and I went to this 1-hour CLE. That makes me an ace. not so quick. This is how I tend to think about this. And I think for a few reasons, this is maybe the best approach to take. Every one of us as lawyers, whether we like it or not, has sort of now become specialists. I think that the days of the general practitioner are, they're limited. Let's just say there are certainly parts of the state where you do just out of necessity have more general practitioners. But I think what you generally find in the larger, more urban areas is that lawyers tend to specialize. And so it is not a weak thing to say to someone, you may want to call, if you're a family lawyer, you may want to call a criminal defense lawyer because they've got a different set of tools in their toolbox than a family law attorney. You may, as a family lawyer, want to refer it out to a lawyer who specializes in CHIPS cases because they've got a whole different set of tools in their toolbox. They understand the rules of juvenile procedure. They understand, how things tend to work with these case plans. You may want to, if you are a criminal lawyer, you may want to refer and get a family law lawyer involved to help with the custody case. Or if you're the family lawyer, you might say, well, I'm comfortable handling the OFP, but not the CHIPS or the assault. So it's not a sign of weakness to say we need to get another professional involved. And one thing that does is, number one, it establishes credibility with your client. But second, I think that it takes away some of the pressure that you may face as a practitioner if you're trying to be the best family law lawyer you can for someone and handle their divorce custody case to the best of your ability, but something happens in the criminal file and they're found guilty. That kind of tarnishes that relationship that you have with the client. I know there are lawyers, family law lawyers, very reputable family law lawyers who never handle orders for protection because they want to preserve their standing when it comes to handling the divorce. And so they will always refer people out to either a criminal defense lawyer or a lawyer that, family lawyers, criminal lawyers tend to be the lawyers that can do OFPs. They're kind of a hybrid. They tend to do that so that the relationships that they have can be maintained and so the client can get the best kind of advice that they're entitled to. If there are any questions, I know we've got just a couple of minutes, be happy to answer those. So Sarah, I'll turn it back over to you.
We haven't had any questions come through yet, but if you do have a question, please enter it in the chat and we'll make sure it gets related to Jason.
Anything coming your way, Sarah?
Not yet, just a couple of comments of thank you, excellent presentation.
Thank you. Thank you. I appreciate that. It's so hard. It is so hard to gauge whether people are just falling asleep at the wheel or at least, moderately interested because we can't see you. So I'm glad to hear that at least some of you got something out of this. And again, my hope was to give a presentation that assumed that none of you were experts in any one area so that we could at least have a cohesive conversation about all the intersecting of these different case areas. So if you have other questions too, my email address is here and I'd be happy to answer those anytime. So thank you.
Looks like we did just get one question coming through.
Okay.
The question reads, Dr. Lundy Bancroft holds that a man who abuses his child's mother can never be a good father. Why doesn't family court work more closely with domestic abuse advocates?
Well, a couple of thoughts on this, and I don't profess to have the answer, but here are a few of my observations. One, I do think that as social science has progressed, and the concept of domestic abuse has blossomed into, you may want to look this up when we're done, the wheel of domestic abuse. And there's this set of materials that I can't remember the name right now, and I apologize. I'm kind of doing this ad hoc, but there's this wheel, and it's like a pie, right? And there's all these different forms of abuse. At the center of the wheel is power and control. On the outside is physical and sexual assault. And in the middle, there's all these different pieces like financial abuse, or using litigation as a weapon, or trying to coerce, different things. That is to say, I think that we're probably in a better position 20 years ago, 30 years ago on the issues now than we were then. It's not to say we have all the answers, but I do think there's a certain level of sophistication that is creeping its way into the court system. I also know that there are a lot of nonprofits that offer support for victims of domestic abuse, and those folks who are allowed to come in and serve as advocates in the courtroom, sit within the counsel table, is something that I know for the victims is appreciated. Really, all it's going to take in order for the judiciary to embrace a particular view, a particular model, is for folks to learn about it. And what better way than to maybe look for different CLEs, or more to the point, have that type of presentation occur at the annual Family Law Institute or something else. Change tends to happen from, in particular, counselors and therapists who are experts in development and family dynamics and psychology, as opposed to lawyers. We kind of react to the new literature when it comes to social science. So it's a long and kind of convoluted way of answering that question. But I tend to agree. I mean, it's the court system always seems to trail what's going on. It's not meant to be cutting edge. It trails what people are doing. So.
Well, we are a little bit past 1 o'clock. There was one other question that came in. If you have time to respond to that.
Sure.
Okay.
Happy to.
The question reads, if the court does not find PC on request for change in circumstance situation, is the strategy to ask for an appointment of a guardian ad litem?
So can you say that question again?
Sure.
Make sure I get it.
If the court does not find PC on request for change in change of circumstance situation, is the strategy to ask for appointment of a guardian ad litem?
Well, if you're modifying and the court denies the motion, you kind of find yourself in a tricky spot, because the court has already denied your request. There's a statutory limitation for how many times you can file a motion to modify. And typically it's, I think, 1 a year, if I'm recalling correctly. And the practical side of this is that guardians are in great demand right now. And unless there's a mandatory appointment, judges seem to be reluctant to allow the resource to get out unless it's a mandatory appointment. And if there was no finding that it's appropriate to move forward to the evidentiary hearing, there's no requirement for a mandatory appointment. So you're kind of out of luck when it comes to a guardian. What would I do in that case? I would tell the client, keep documenting, so that when and if you decide to move forward again, if something happens, you've got a very clear paper trail with great detail about what's gone on. The more detail you have, the more credible you're going to look in the eyes of the court.
Great, thank you. That's all we've got in the chat, so I think we can go ahead and wrap up here. Thank you very much for this presentation.
You're welcome. Thanks, everybody. Have a great day. It's 30 degrees outside, 50 degrees warmer than the other day. It's tropical.